Okay, we're looking at the docket of George Metz's case, Rogue Nation, against the city of Easley in South Carolina. Someone kindly sent me the attachment 2 supporting documents to the amended complaint. And before I just get into that, let's have a look at what's gone on here. Because George did apply to bring this case without paying the filing fee. Excuse me. You can see at docket number 13, report and recommendation. It is recommended that the plaintiff's motion to proceed in forma pauperis be denied. So that was the recommendation of the magistrate judge. However, after some motions, in June, we get this. Upon review of plaintiff's long-form motion to proceed in forma pauperis, the court finds that it would be overly burdensome to require plaintiff to pay the filing fee. So he didn't have to pay the filing fee. So he's been able to proceed with this case without paying the filing fee. I know some may have some opinions on that. So this is the amended complaint. I think it would be the first amended complaint of George D. Metz against the city of Easley, South Carolina. So it's a federal question. The basis for jurisdiction is it's a 42 USC 1983 Monell claim. Going down. Statement of claim. So, the city of Easley, South Carolina passed an unconstitutional ordinance that restricts my rights of free press to gather information on public employees in the course of their duties. Copy of the ordinance is attached. Statement of claim attached. I think when we come to look at the attachment, there isn't a copy of the ordinance attached, so that's quite an error. Anyhow, relief. Punitive damages, $1 million. The reason being is that these folks knew it was unconstitutional because we told them instead of doing proper research, they passed it anyway. Know that it would be a prior restraint on our rights. Instead of doing proper research, they passed it anyway. Know that it would be a proper restraint on our rights. I think that should be knowing. Oh, they did so knowingly and willfully. I think he home educates his children. We also pray the court declares that part of the law dealing with consent in public places to be unconstitutional. And that was filed by George Metz on the 24th of July. Well, actually, it didn't hit the filing until we'll have a look at the attachment. I think it's 2nd of August or something. And he's pro se. Right, on to the attachment, which is the more interesting bit. Zoom up the top here. So, yeah, as you can see, 2nd of August. Plaintiff George Douglas Metz II respectfully brings this action for declaratory and punitive relief and complain as follows. 1. George Metz is an independent investigative journalist who focuses on government accountability. 2. Because Easley, South Carolina maintains an unconstitutional recording law, plaintiff and other local journalists are prohibited from exercising their First Amendment rights to engage in news gathering by recording their conversations with others without first getting their consent. 3. Plaintiffs report that have garnered national attention, with many garnering hundreds of thousands of views. Well, they possibly garnered those views, but I mean, once again, ideas of grandeur. Through my First Amendment journalism, plaintiff is able to educate and inform the public about newsworthy topics of public concern and government accountability. 4. Plaintiff covered stories from LA to New York City, but mainly covers the southeast US area. Plaintiff regularly reports from South Carolina, and it was plaintiff and other journalist reports on Easley that made them pass this law. Plaintiff reporting on the mayor and his activities is the reason they passed this unconstitutional ordinance. 5. Even though plaintiff is a resident of Florida, he would still work on and report stories from Easley, South Carolina, if not for his rights being chilled and threat of arrest for openly recording in public places with no expectation of privacy. 6. Plaintiff is aware that the public and press share the same rights of access. We are also aware that anywhere the public is allowed to be, where there is no expectation of privacy, they may record secretly or openly. Plaintiff and we? There's only one of you. 7. Plaintiff is aware that recording is a non-expressive step in the speech creation process and as such is not regulated by the forum doctrine, which regulates expressive acts only. 8. Plaintiff realises that the right to free press is in fact the right to watch over our public employees and report their behaviour to the public so they can make informed decisions about their leaders. 9. Plaintiff realises that no case law from any circuit or SCOTUS is needed for us to exercise and be protected in our right to observe and record our officials from public areas. 10. Plaintiff realises that the right to free press is one of our oldest, most established rights that citizens have, and as such needs no case law in order to establish that the right is well established and should have been known to a reasonable person. 11. Plaintiff realises that only by viewing the recording can the state authorities make a determination about criminal liability. 12. Plaintiff realises that the law's applicability plainly pivots on the content of the recording, namely what the recording captures. 13. Plaintiff realises it is the statute's differential treatment of recordings based on their subject matter, e.g. whether it's a public meeting or right outside the meeting in the hallway, close brackets, that makes the statute content-based, not the words exchanged. 14. Plaintiff realises under South Carolina law it would be legal to secretly record without consent in the very same areas that Easley has made open recording illegal. 15. Even though plaintiff has standing due to injury, he realises that only a willingness to break the law and government's willingness to prosecute are needed for standing. I have no issue stating that I intend to break this law, and the government has already enforced it on a journalist. As we suspected, it had nothing to do with consent, as the young man was in cuffs 60 seconds after entering the building. 16. Plaintiff asserts that this is an unconstitutionally overbroad content-based restriction. Count 1. Easley, South Carolina Ordinance Section 99.01 brackets E. Unconstitutionally favour some recording but disfavour all other recording. 17. Easley law offers police officers robust authority to openly record the public while denying the public the same right to record the exact same circumstances. 18. Section 99.01 brackets E operates as a grant of government permission to openly record certain public events without requiring subjects give consent. In similar other public settings not favoured by government, subjects must have given consent because audio-visual recording is protected by the First Amendment government actions recording. That doesn't make sense. What's he done here? Oh, look, looks like he's got the first line of the next of number 19 slipped in there. I hope this isn't how it went into the court, George. I don't know what the judge will do, whether they'll figure that out. Let's have a look then. So it's in similar other public settings not favoured by government, subjects must have given consent about recording. And then we have 19. Because audio-visual recording is protected by the First Amendment, government actions that favour the recording of particular subjects and events, while disfavouring others, invokes content and viewpoint discrimination and the suppression of protected news gathering. Citation. Differential treatment of recording for different actors can act as, effectively, as a censor to check critical comment. Citation. Here, Easley law singles out a specific subject matter that may be openly recorded, law enforcement activities, and forbids similar recording of other government agents engaged in official acts or ordinary citizens without notice, making this differential treatment unconstitutional. Citations. The law also opens up government-favoured events like press conferences and allows for open recordings, but does not recognise a similar right in other public areas. Count 2. Easley Ordinance 99.01 brackets E violates the First Amendment by prohibiting unconsenting recordings made in public areas. 20. Easley law enacts an impermissible divide by allowing the open recording of the police without specifically informing them, but forbidding any recording of other government actors without notification. It grants journalists a similar right to record staged events preferred by the government without notice, but forbids it in other public places. The law cannot be said to advance an interest in privacy, since it selectively bans unconsenting recordings at other public places disfavoured by the government. Because of this, section 99.01 brackets E is unconstitutional on their face and as applied to plaintiffs, necessitating punitive and declaratory relief. And it's signed by George. So that is his amended complaint. As I said, as you can see, although he said in the amended complaint that he was including the ordinance isn't attached. You've got the attachment 2 I just read, there's a cover sheet, and there's an envelope. Let's see if he's put the ordinance in. It's not clear. Maybe it was in that one. So maybe the court has it. This point, I can't be bothered to look for the ordinance online. Good luck, George. Unless they want you to pay you go-away money. I think you'll fail with this one, although it didn't cost you anything to file it. More expense for the taxpayers to endure. Thanks for watching.